This is Angela, and you're listening to the Study for the Bar in Your Car podcast. This is the podcast for people who want to study for the bar exam via audio. Whether you're in your car, on the subway, in the shower, you can maximize your study time by listening to this bar study podcast. I'm Angela. I'm a law student from George Mason University, Antonin Scalia Law School. Honestly, I've created this podcast to help me pass the bar. If it helps you pass the bar, that's a bonus. So here's how it works. I am introducing these topics. I'm not a lawyer. I'm not an attorney. I am not barred by a state bar, but I am barred by two federally recognized Native American tribes who have their own judiciaries. Now, I don't know all the answers to all this bar stuff, and so you're probably wondering, well, why are we listening to you? Well, technically, you won't be listening to me. You'll be listening to my two AI buddies. I'm going to call them Maud and Claude, and they will explain all these concepts for you. So what I've done is I've taken all my bar study notes that I've taken, and because I've taken the bar more than once, I've got a lot of notes. I've taken all my notes, I've thrown them into AI. Actually, that makes it sound like it's been unorganized, but it's been actually quite organized. I've put my bar study notes into AI. And these are notes that I've taken down from being in class. I've created outlines. I've done the most. And now AI is taking those concepts and it created a podcast. So you're going to be listening to a podcast within a podcast. I'm going to top and tail these with information, a little bit about my life, my bar journey. Sometimes I'll have friends join me, sometimes not. What I found generally is that these AI bots or AI in general can dissect these bar rules and rule statements in a way that I guess I would say is not humanly, but it can digest it and regurgitate it and spit it out into sort of bite-sized chunks that is easily understandable, at least for me, and maybe for some others as well. So a few things before I take this over to my AI friends. Remember, I'm not a lawyer, so I'm not giving legal advice. Number two is be safe on the roads. If this podcast is going to distract you, or if thinking about Civ Pro or contracts or whatever is going to distract you, just hit pause and then pick up later. Number three, AI isn't always 100% correct. I try to make sure that it's a quality product. I listen to the podcasts that Maud and Claude do, and I try to, as far as I know, as being someone who has graduated from law school twice, which is another story because I'm both British and American, and I've been to law school in two different countries. But as far as I know, what I've seen, the information that the AI has produced appears to be correct. Now, I'm not asking for donations, even though I am such a poor law student. But what I am asking for is if you are an attorney, or if you know an attorney who needs legal work done, so motions, appeals, any sort of legal writing, then call on me. You can contact me at hello@legalwriterandlawclerk.com. I know it's a very long web address. And for this podcast, if you want to say hi to me on the podcast, you can email me at podcast@studyforthebarinyourcar.com. Without further ado, here are our AI hosts. Take it away, Maud and Claude.
Welcome to this deep dive, and a special welcome to you, Angela, from Study for the Bar in Your Car. Thanks so much for sharing your notes. Really fantastic stuff.
Yeah, absolutely great notes.
Today, our mission really is to help you navigate state law in federal court and federal common law, pretty crucial areas for the bar.
Definitely key topics. They intertwine quite a bit, too.
Okay, so let's try and unpack these ideas. Where should we start? Part one, maybe? State law in federal court.
Sounds good. Let's start there.
So, Angela, your notes kick off, quite rightly, with the Erie Doctrine, the big one.
The cornerstone, yeah. Erie Railroad v. Tompkins. Everyone remembers that case name, hopefully.
Right. So what's the the core principle there? And maybe more importantly, why does it matter so much? Why is it fundamental?
Well, the basic rule, right, is that in diversity cases, so citizens of different states suing each other in federal court, the federal court generally has to apply state substantive law.
Okay, substantive law from the state.
Exactly.
Yeah.
But for procedure, they use federal procedural law, like the federal rules of civil procedure.
Got it. Substance state, procedure federal. But the why?
The why. Two big reasons, really. First, preventing forum shopping. You don't want people choosing federal court just because they think, oh, federal law might give me a better shot than state law on this particular issue.
Makes sense. Keep the playing field level.
Exactly. And that ties into the second reason, equitable administration of the laws. The outcome of a case, ideally, shouldn't dramatically change just because it's heard across the street in federal court instead of the state courthouse. Same substantive rights should apply.
Okay, that clicks. Now, your notes, Angela, also bring up how federal courts figure out what the state law is. It's not always crystal clear.
Oh, definitely not. I mean, the gold standard is a decision from the state's highest court on that exact issue. If that exists, the federal court follows it, period.
But what if the state Supreme Court hasn't ruled on it?
That's where it gets interesting. The federal court then has to essentially predict how the state's highest court would rule if faced with that question.
Predict? How do they do that? Like, gaze into a crystal ball.
Well, not quite. They look at, decisions from lower state appellate courts, relevant state statutes, maybe trends in the state's law,
Yeah.
sometimes even legal scholarship or treatises. They try to make an educated guess, an informed prediction.
Okay, so it's an analytical process. Now,
Yeah.
the substance versus procedure line you mentioned, Angela's notes highlight this as, well, tricky. Why is that distinction so challenging?
It's the heart of many Erie problems. Because, the labels aren't always perfect. Sometimes a state rule looks procedural, like how you file something or a statute of limitations. But it's so bound up with the state-created right itself that applying a different federal rule would actually change the outcome. It affects the substance of the right.
So it might be labeled procedure, but acts like substance in effect.
Precisely. The Supreme Court calls these outcome determinative tests, though it's a bit more nuanced now. You have to ask if applying the federal rule instead of the state rule would significantly affect the result and encourage that forum shopping we talked about.
Okay. Angela, your notes have a good example here about state laws that might prohibit class actions for certain damages. How does Erie handle that?
Right. That's a great one. So say a state has a law that says no class actions allowed for recovering these specific statutory damages.
Okay.
A federal court hearing that state law claim, maybe under diversity jurisdiction, is generally not bound by that state prohibition. Why? Because the federal rules of civil procedure, specifically Rule 23, govern how class actions work in federal court.
So Federal Rule 23 takes precedence.
Usually, yes.
Yeah.
The availability and management of class action is generally seen as procedural in the federal system. So the federal court would likely apply its own Rule 23 standards, even if state law says no. It shows how federal procedure often governs the how of the lawsuit in federal court.
Makes sense. The notes also mention forum selection clauses. Quick thought on those. State or federal law?
Federal law generally governs their enforceability in federal court. The Supreme Court has indicated that managing where cases are heard within the federal system, based on these clauses, falls under federal procedural concerns.
Okay, good to know. Let's shift gears slightly to Rule 4, service of process. Your notes, Angela, point out that federal courts can sometimes use state law methods for service.
That's right. Federal Rule 4 is actually quite flexible. It explicitly allows service to follow the state law rules for service, either in the state where the federal court sets or in the state where service is actually made.
So it borrows from state procedures.
It does. It gives plaintiffs more options. If state law allows a particular method, like maybe certified mail under specific conditions, federal plaintiffs can often use that same method.
And you have that Texas example in your notes, restrictive registered mail.
Exactly. If Texas law says that's valid service, Rule 4 lets you use it for a federal case involving service in Texas or from a Texas federal court. It incorporates state practice.
But federal rules also have their own methods, right? Like the CEO example in your notes.
Absolutely. Rule 4 also lays out federal methods like delivering the summons and complaint personally to an individual or for a corporation, delivering it to an officer, managing agent, or general agent. So as your notes say, serving the CEO at the headquarters would likely be valid under the federal rule, even if state law perhaps specified serving, say, only the registered agent. Federal rules provide independent ways to achieve service.
Okay, got it. Now, personal jurisdiction, or PJ, big topic. Your notes, Angela, emphasize that federal courts usually look to state law first. Why start there?
It comes back to Rule 4, specifically Rule 4K1A. It basically says that serving a summons establishes personal jurisdiction over a defendant who is subject to the jurisdiction of a court of general jurisdiction in the state where the district court is located.
So the federal court asks if the state court could hear the case.
In most situations, yes. They effectively step into the shoes of a state court in that state and apply the state's long-arm statute first. Does the state law authorize jurisdiction over this out-of-state defendant?
And if the state long-arm statute says yes, is that the end of it?
Not quite. That's just step one. Step two is always the U.S. Constitution.
Due process. Minimum contacts and fair play, like your notes mention.
Exactly. Even if the state statute allows it, exercising jurisdiction has to be constitutional. Does the defendant have sufficient minimum contacts with the forum state so the jurisdiction doesn't offend traditional notions of fair play and substantial justice? That's the classic test from international shoe.
And your notes mention purposeful availment as key for minimum contacts.
Crucial concept. The defendant has to have purposefully availed itself of the privilege of conducting activities within the forum state, thus invoking the benefits and protections of its laws.
So like your example, Angela, targeting customers in a state for sales, that counts.
That's a textbook example of purposeful availment. They're deliberately reaching into the state. Accidental or random contact usually isn't enough.
Okay. But then there's that weird situation your notes mention, just being briefly present in the state. Tag jurisdiction?
Right. Transient jurisdiction is still generally good law based on Burnham. If you physically enter a state, even very briefly, and someone personally serves you with, summons and complaint while you're there,
You're tagged.
you're tagged. And generally, the state court, and thus the federal court in that state, has general personal jurisdiction over you, meaning you can be sued there on any claim, even if it's totally unrelated to why you were in the state.
Wow. Unless you were tricked into entering the state just to be served.
Exactly. There's an exception if your presence was obtained by fraud or force just for service. But otherwise, physical presence plus service generally equals jurisdiction over the person.
Wild. Okay, one last PJ point from your notes. Bulge jurisdiction. What's that about?
The 100-mile bulge rule. This is under Rule 4K1B. It applies only to parties who were added later in the case specifically. Parties joined under Rule 14, impleader third-party defendants, or Rule 19, required parties.
Okay, not the original defendant.
Correct. For those later added parties, the federal court can exercise personal jurisdiction if they are served within a U.S. judicial district and not more than 100 miles from where the summons was issued the courthouse.
Even if the state long arm wouldn't reach them.
Even then, it allows the court to bring in necessary or related parties who are geographically close, even if they lack minimum contacts with the state itself, to ensure a more complete resolution of the dispute. But again, it doesn't help establish jurisdiction over the original defendant.
Got it. Okay, moving through your notes, Angela. Choice of law. What's the rule for a federal court in a diversity case?
Simple but crucial. The federal court applies the choice of law rules of the state in which it sits.
So not federal choice of law rules.
Nope. It applies the state's rules for choosing which state's substantive law applies. So a federal court in New York uses New York's choice of law rules to decide if New York law, or maybe New Jersey law or Connecticut law, governs the actual dispute. This is the Claxon rule, another key part of the Erie framework ensuring consistency with state courts.
Right, preventing different outcomes based on forum choice again. And finally, for this part, preclusion, claim, preclusion, issue preclusion. Your notes say federal common law governs this for diversity judgments.
Yes, that's the rule from Semtec. The preclusive effect, meaning whether a judgment prevents relitigating the same claim or issues in a later case of a judgment rendered by a federal court sitting in diversity, is governed by federal common law.
Okay, federal common law.
But, and this is a big but you need to remember, the content of that federal common law rule will usually be the preclusion law of the state where the federal court sat.
So it borrows state law again.
Often, yes. Unless applying the state's preclusion rule would somehow undermine a specific federal interest. But generally, for diversity judgments, federal courts will give the judgment the same preclusive effect it would have in the courts of the state where that federal court is located. It promotes uniformity within that state.
That makes sense. Okay, wow, that was a lot on state law and federal court, but your notes really laid it out well, Angela.
Really good coverage, yeah.
So let's transition now to the second major topic, federal common law itself. Your notes introduce this as judge-made federal law. When does this even come up?
Right. So federal common law is created by federal courts when there isn't a specific federal statute or constitutional provision on point, but there's a really strong need for a federal rule, usually because a significant federal interest is involved or national uniformity is essential.
Filling the gaps, basically.
Exactly. Congress hasn't spoken, the Constitution doesn't directly address it, but there's a uniquely federal issue that needs a legal rule. So the federal courts step in.
And your notes mention Semtec again here. How does that fit the federal common law picture?
Semtec is a prime example because the Supreme Court needed a rule for the preclusive effect of federal diversity judgments. No statute dictated it. So the court said, okay, this is an issue touching on the power and effect of federal court judgments of federal interest. Therefore, federal common law provides the rule.
And then, as we said, that rule often just adopts state law.
Right, which shows how federal common law works. It identifies the need for a federal rule, but might still incorporate state law principles if they align with federal interests.
So when does federal common law generally apply? Your notes suggest it's pretty limited. Why the hesitation?
Because federal courts are generally supposed to apply law, not make it wholesale. Lawmaking is primarily for Congress and state legislatures. So federal common law is reserved for pretty specific, narrow areas.
Like what? Can you give some examples, maybe not in the notes?
Sure. Classic examples include disputes between states like over water rights or boundaries. Also, certain aspects of U.S. foreign relations or the legal consequences of actions taken by federal officials or interpreting federal government contracts, areas where state law just wouldn't make sense or where a single uniform national rule is really necessary.
Got it. So not something courts create lightly. And your notes touch on this idea, federal common law can displace state law.
It can, yes. When federal common law applies because of a significant federal interest, it operates under the Supremacy Clause, just like a federal statute would, and it can override conflicting state law.
But courts are reluctant.
Very. They try hard, as we saw with Erie and preclusion, to respect state law and only create federal common law when truly necessary. They often look for ways to weave state law into the federal framework where possible.
Okay. Now, something your notes hint at, Angela. The federal rules of civil procedure. Can they be seen as a type of federal common law?
That's an interesting way to think about it. While they're created through a specific process under the Rules Enabling Act, they function like federal common law in practice within the court system. They are judge-approved rules, ultimately by the Supreme Court and Congress, that provide a uniform code of procedure for federal courts nationwide.
And they trump state procedural rules in federal court.
Generally, yes. If a federal rule is valid under the Rules Enabling Act, meaning it doesn't abridge, enlarge, or modify any substantive right, and the Constitution, and it directly conflicts with the state procedural rule, the federal rule governs in federal court.
Like your Rule 15 example, relation back of amendments.
Exactly. If FRCP 15 provides the rule for when an amended pleading relates back to the original filing date for statute of limitations purposes, that federal rule applies in federal court, even if state law has a different, maybe stricter relation back rule.
Okay. Final point here, and your notes make this distinction clearly, Angela. Federal question jurisdiction versus federal common law. Why is it crucial not to mix these up?
Super important distinction for the bar. Federal question jurisdiction, Section 1331, is the basis for getting into federal court because your case arises under federal law.
Okay, the ticket into federal court.
Right. Federal common law is one type of federal law that can provide that ticket. If your claim is created by federal common law, then your case arises under federal law and you have federal question jurisdiction.
But federal question jurisdiction can come from other federal laws, too.
Absolutely. It can come from a federal statute creating your cause of action or from the U.S. Constitution directly. Also, as your notes mentioned with the creation test and embedded federal questions, sometimes a state law claim can still get into federal court under federal question jurisdiction if it necessarily raises a substantial and disputed issue of federal law. That's different from a claim based purely on federal common law.
So federal common law is a source of law, while federal question jurisdiction is about the court's power to hear the case based on that law or other federal law.
You nailed it. That's the key distinction.
This has been incredibly helpful. We've really dug into these complex topics. And again, thank you, Angela, for sharing your notes from Study for the Bar in your car. They were a perfect guide.
Absolutely. Excellent notes. Really hit the key points.
Any final words of encouragement for Angela and everyone else hitting the books for the bar?
Just keep focusing on the underlying principles. Why does Erie exist? What's the balance between state and federal power? When do federal rules take over? Understand the why, not just the what,
Yeah.
and work through those hypos, like the ones in Angela's notes. Seeing how these rules apply in concrete situations is key. You can definitely master this.
Angela, seriously, thanks again. We hope this deep dive, using your notes as our map, has really solidified these concepts for you. Remember the core ideas, practice applying them. It's tough stuff, no doubt, so keep reviewing. Maybe think about, what specific Erie scenarios still feel a bit fuzzy, or where might federal common law pop up next. Keep digging, keep working hard. You've got this. Best of luck.
Yeah, best of luck.
And for everyone listening, maybe ponder this. As technology and society evolve, creating new kinds of disputes, where might we see federal courts needing to step in and create new federal common law because Congress hasn't acted yet? Something to think about.
Okay, that is going to wrap it up for federal law in state court and federal common law. Funny story, when I was taking the bar exam at one point, there was a question on the bar about federal common law. And I'd never heard it phrased that way. Like, I've heard common law and I heard federal law, but I never heard federal common law. And I'm like, that is a made-up term. That answer is obviously wrong. And it was probably the right answer, and I probably got that completely wrong. But there you go. So now you know federal common law is a thing that exists. It is a phrase that exists, and it is a thing that exists. Anyhow, I hope you enjoyed that with Maud and Claude. That is going to be it on this episode. We have several more episodes coming up. In fact, there are 9 episodes in civil procedure, and there's also going to be a bonus 10th. You can email me at podcast@Study for the Bar in your car for any sort of podcast stuff. If you're an attorney or you know an attorney who needs extra legal work done, you can email me at hello@legalwriterandlawclerk.com. Anyhow, thanks a lot, and we'll see you on the next episode.